latest immigration news. In this video, we'll talk about the latest in immigration. My name is Bijoux Ngwanda. For those who do not know me, I am an immigration lawyer here based in DC, but I do work with individuals across the country and around the world because we are dealing with complex US immigration laws. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, again, please go ahead and share, like, don't forget to comment below, and also don't forget to join us on our private Facebook group. Please click the link in the description box, join us, and post your first question so that we can be able to assist you in answering questions over there as well. Okay, so let's get right into it. What's going on with immigration? We have two things to share. The first news is that the Cuban and the Haitian family reunification parole program is back. For some reason, it was suspended. I'm not going to get into the details of why it was suspended, but it is back. Who is eligible? You might be eligible to apply for parole for your relatives in Cuba or in Haiti under this program if you are either a U.S. citizen or lawful permanent resident, you have an approved I-130 petition for a Cuban family or Haiti family member, an immigrant visa is not yet available for your relative. This is the key word. Immigrant visa is not yet available for your relative. For qualifying relative, remember that visa is immediately available. But for other members, for example, siblings, when the visa is way too far away to become available, the one that you have to wait online for it to become available, that's the one they're talking about. An immigrant visa is not yet available for your relative, and you receive an invitation from the Department of State National Visa Center, NVC, to participate in the program. Okay? You have, again, to receive an invitation to participate in the program in order for you to qualify. The beneficiary, the person that you're bringing here, must be either a Cuban national living in Cuba or a Haitian national living in Haiti, and have a petitioner who has been invited to participate in this program. Petitioner must have been invited to participate. Okay? You can check your eligibility under your USCIS.gov website to know whether or not the beneficiary or the petitioner is qualified under those circumstances. Okay? This is really good, I guess, because of what's happening in Cuba or what's happening in Haiti. And you know that processing time and a long period of time waiting at NVC, and then visa is not immediately available. They really want to help out. And this is a good thing, really, to take opportunity of. For more information, really, you can either visit USCIS.gov. Information is pretty much all over the place right now. Even on ICE website, we have that. So the second news, and the last one for today, second news is that USCIS is changing its interpretation of 3 years and 10 years bar. This is major for certain applicants only. Not everybody will qualify for this. This is major. What happened was Gomez v. USCIS happened. It's a lawsuit. Basically, USCIS will allow certain applicants like Gomez to adjust status without filing for a waiver or leaving the US for their 3 years or 10 years bar to run outside of the US. Basically, those people will adjust status inside of the US. In order to qualify, what are the qualifications? You must be someone who actually, first of all, came to the U.S. the first time with a lawful visa, pretty much entry with inspection with a valid visa. And then after a while, you accrue unlawful presence. You trigger those either 3 years or 10 years bar. Remember, unlawful presence of 6 and less than a year, you trigger 3 years bar, or 1 year and more, you trigger 10 years bar. So pretty much trigger those bars, and then you leave the US on your own, right? You leave the US, and then you go out, for some reason you come back. Again, you go to the embassy and you get a valid visa, and you come back without misrepresentation or fraud. You just state the fact the way they are, but for some reason they give you the visa and you're here. And now you find yourself qualified for adjustment of status. You apply for adjustment of status, but unfortunately USCIS said that, well, we cannot adjust your status based on unlawful presence, previous unlawful presence. Unfortunately, it's not gonna go this way anymore, because I believe the fact that they allow you to come here lawfully for the second time without seeing it, why would they actually prevent you from adjusting status? It's pretty much like their fault. So that's what's happening. So USCIS is changing its interpretation of 10 years and 3 years bar. It only applies to certain applicants. Again, qualifications are: first time you enter the US lawfully with a lawful visa, entry with inspection with a lawful visa. Then while you stay here, you trigger either 3 years or 10 years bar. Then you leave the US, come back again lawfully with a lawful visa, and at some point you want to adjust status. They refuse to adjust status based on previous unlawful presence. Right now they can't do it anymore because of the fact that you came the second time lawfully. So they have to calculate all those years here. Those three, either if you trigger 3 years or 10 years bar, they have to calculate it without you leaving the United States, and they are not requiring a waiver for it. So that's what happened with Gomez v. USCIS. Very good news, very specific. If you miss anything, please listen to it again, because some people will be calling to ask the same question, but listen to it again because it's very specific. It does not apply to everybody. If you never left the US after triggering 3 years or 10 years visa, this policy, this new interpretation of 3 years and 10 years does not apply to you. So that's what it is. This is it for today. But if for some reasons you need a consultation with me for your case, or you want us to assess your case and provide the best legal advice, please call 202-751-2180, email bijoux.ngwanda@gmail.com. Consultation fees apply as usual. Until next time, bye-bye.